And also, I never invoked my right as a Native American Indian chief. This time I did. So therefore, I will not miss not one court date, I assure you. Can you
I'm
please?
not sure what you being a Native American chief has anything to do with you coming to court.
Because I represent a sovereign state, and as a sovereign state, I have the right to have these cases heard before the United States of America. Can contact the Embassy of Morocco.
No, so I'm familiar with that treaty, and it is a trade treaty. It has nothing to do with your right to commit crimes anywhere you feel like.
No, ma'am, it has nothing to do with me committing crimes, but they will vouch that I am royalty, and Morocco has granted me as part of their royalty, and they will vouch for me, I assure you.
You can't be a royalty in Morocco and a Native American. That's not possible.
Defendant cannot be declared incompetent by being delusional in itself.
And
That's
I explained to you what the evaluator opined, that your delusion is impeding your ability to assist in your own defense. That's what the evaluator. Am I characterizing that correctly, Mr. Mercer, Mr. Ainati? That's what it sounded like to me.
In what way, though? How is it impeding?
You're asserting defenses that don't exist.
Such as?
That stuff.
Today, we dive into the baffling case of Mr. Evans, a man who takes the sovereign citizen ideology to a whole new level. In this compilation, we've rolled all 3 of his court hearings into one convenient package with timestamps and chapters in the description. But Mr. Evans isn't your average sovereign citizen because he insists that he is a Native American chief, all while simultaneously claiming to be the heir to Moroccan royalty. Despite these grandiose titles, he has offered no verifiable proof to substantiate his claims, instead demanding that the court honor the special sovereign rights he has, quite literally, bestowed upon himself. Throughout this 3-part series, Mr. Evans demonstrates an insufferable sense of entitlement and a profound disconnect from reality. His claims of sovereignty and royal lineage are as unsubstantiated as they are outlandish, leaving everyone wondering if he should be evaluated by a psychiatrist for what appears to be severe delusions of grandeur.
Did the letter I mailed in, Your Honor?
I did not.
Is the court ready?
Yes.
Okay, I mailed the
One
letter.
second, Mr. Evans. So this is Sylvester Evans. It's 38031231999215. And I don't believe you were here, Your Honor, on Monday when Mr. Evans was arraigned. But Mr. Evans at that time indicated he wanted to represent himself. And he's also indicated that to me today. I did go over the waiver of attorney on pretrial and arraignment form with him, and explained it to him and talked about it. It sounds like when I spoke with him, because he's in custody right now, I know he wants to address his in custody status with the court, but I figured this needs to be addressed first. We discussed if he's in custody, he needs access to certain things and that unlikely he can get. So he would want an attorney on standby to assist him with that. And I said that I don't have any conflicts, so I don't have any issues doing that if that's the case. But just so the court's aware. But I know he wants to address his conditions of release. But he also wanted to represent himself.
Okay, and I believe Judge Freund did do the jail calendar on Monday. So did you say competency was raised? I didn't quite understand that piece.
Oh no, that I was talking about the other person was who I started to talk about.
Got it.
And then when Mr. Evans walked in, I just said we'll get to that when we're done with Mr. Evans.
Got it. Thank you. Thank you for the clarification. All right, so Mr. Evans, so we have not yet done the arraignment, right?
No, it was done.
It's done. So
Sunday. And the city doesn't believe there's any change in circumstances, so would object to defendant's motion
I
to
guess
release or adjust bail.
Oh, thank you, Ms. Chenoweth. I guess I just for my clarity. So this was on Monday, and we set it again for today for what specifically?
Pre-trial and the tracking reviews.
Okay.
Because the court set bail or bond, we set the pre-trials pretty quickly.
I would like to speak to Your Honor before we disconnect if possible, please.
All right, Mr. Evans, so it's my understanding that you do not want an attorney to assist you. Is that correct?
Like you said, if he could be on standby, I would like to represent myself because I invoked my right as a Aboriginal Native American Indian chief. That's why I asked if you got that letter. So I have certain constitutional rights that's afforded to me. In addition to that, I have a leg injury where I'm on crutches and they have me in 23-hour lockdown. I didn't do anything wrong. And I was trying to see if it's possible, based on the fact that I invoked my right as an Aboriginal Native American Indian chief, that I definitely will appear at every appearance if I could get a pre-recognizance bond due to the circumstances. I assure you I'll show up, especially that I invoke my right as a Native American Indian chief.
And as the prosecutor stated earlier, Mr. Williams, I guess, what is the change? It doesn't sound as if you're noting any change of circumstance from when the court saw you on Monday and set bail.
Well,
I can honestly say I don't recall defendant mentioning the Native American part on Monday, but he did discuss the other thing in quite more length than he actually even is today. So the court did have that before it. Now, as far as the other piece that he's presenting today, I say his positions, that doesn't change anything and there's no proof.
I sent the proof in the letter that I mailed out.
Wasn't provided to the city. I haven't seen any proof. And I would say that's not a change in circumstances.
I mailed the letter out on.
Like I said,
I mailed the letter out on Tuesday with the evidence and the proof invoking my rights as a Native American Indian chief. So I'll be working to get this case removed to the federal courts. I need to also file in the federal courts a notice to remove as well. And it's going to be extremely difficult for me to do that from here in prison. So that's why I was asking if I could get a PR bond. I assure you I'll show up. I'm not going to play with my rights like that as a Native American Indian chief. In addition to that, I'm in 23-hour lockdown with my crutches and it's affecting my leg. I broke my tibia and fibula in 5-6 different places. And the muscles and the nerves in my leg are getting worse because I'm not able to rehab it like I'm supposed to.
and Ms. Chenmuller, seeing that I wasn't here on Monday, what is the bail currently set at?
500 cash or bond on each of the 6 cases.
And does Mr. Williams have, what is his FTA history?
He does have a substantial warrant for ADP history, including an active warrant out of Tacoma Municipal Court. Also, has not complied with court orders, and that he repeatedly returns to the airport. We have 4 pre-trials and 2 reviews involving those allegations, the same allegation before the court today. Has warrant failure to appear history in pretty much every case.
What is his date of birth? I'm trying to find him on Jabs.
My last name is Evans, it's not Williams.
It is.
And also, there's no evidence that I was trespassing. Each time I was there on valid personal travel. So this case lacks evidence, which is also why I asked to have it dismissed in the letter as well.
He went into that on Monday as well.
And also, I never invoked my right as a Native American Indian chief. This time I did. So therefore, I will not miss not one court date, I assure you. Can you please?
I'm not sure what you being a Native American chief has anything to do with you coming to court.
Because I represent a sovereign state, and as a sovereign state, I have the right to have these cases heard before the United States of America.
Have you ever heard of the epic tale of the Black Indians in California? Well, if not, we have got you covered over the next 5 minutes.
The Supreme Court of the United States of America, and in the letter, I put the details that prove what I'm saying, and also it should prompt everything to be moved to the United States Supreme Court, especially with some of the details that I put in there regarding my circumstances and what I have going on, which I'm sure Chief Justice Roberts can verify once the process or whatever, which I'm trying to go through the process now, but it's going to be very difficult to do this from inside the jail. But as a chief of a sovereign tribe that's federally and internationally recognized, I have the right constitutionally to go to, I have immunity, and I have the right as a sovereign state to have this cases heard before the United States of America. In addition to that, I have different types of immunity that I fall under as well.
All right, Mr. Evans, so I gave you an opportunity to speak just to make sure I understood exactly what was happening in this case since I was not the judge on Monday. I have had an opportunity to review your criminal history, and I do see that you have had warrants in pretty much every case that has been filed against you that I can see in the state of Washington. So right now, I'm not hearing any change of circumstance that would give me any change in circumstance that would allow me to change the bail from $500 on each case. So that will remain as previously set on Monday. Additionally, we need to address the fact that you are requesting a waiver of right to an attorney. I will note that I don't believe that that is in your best interest. I think an attorney would be helpful to you. However, if that is what you would like to do, I want to make sure that you understand that you have 1, 2, 3, 4, and you have 4 cases that are pre-disposition, and it sounds as if you have 2 review matters, which means you've already entered into some sort of plea on those cases. But on your new cases, do you understand, Mr. Evans, that these are gross misdemeanors?
Yes, ma'am.
And you understand that with that, you could potentially serve up to 364 days in jail and or pay a fine of up to $5,000?
Yes, ma'am.
Okay, you understand that you do have a right to have an attorney, have a lawyer represent you in all stages of these proceedings. And if you cannot afford a lawyer, that you have the right to request a public defender.
Yes, Your Honor.
And that a public defender, if you qualify, will be appointed to represent you.
Yes, Your Honor.
And that you may be at a disadvantage if you proceed without a lawyer.
Yes, Your Honor, as I previously stated.
Okay, Mr. Evans, I heard everything that you had to say. I just need to make sure that you understand the rights and that you understand that you'll be required to follow all the laws of evidence and court rules which apply to this case.
Yes,
Do you
Your
understand that? And that these laws and rules can be technical and complex, and that you may not fully understand them without a lawyer.
Yes, Your Honor.
Okay, and that you realize that by proceeding as your own lawyer, if you do not represent yourself in a competent manner, that you will not be able to obtain a reversal of a conviction on the grounds that you received inadequate representation.
Yes, Your Honor.
And are you aware of the risks and disadvantages of proceeding without a lawyer?
Yes, Your Honor.
And knowing that you still choose to represent yourself, knowing the risks, you freely waive your right to be represented by an attorney.
Yes, Your Honor.
So you are waiving your right to be represented by an attorney.
Yes, Your Honor.
All right.
And also, would you be able to look into a oral motion to dismiss due to lack of evidence at this hearing?
You would have to do that, Mr. Evans. You are acting on your behalf as an attorney. So that is a motion that would need to come from you and or your attorney.
I actually mailed in a letter. I was trying to see if the courts received that letter because that was in the letter that I mailed.
Okay, we do not have that letter at this time. So we're going to set this matter for another pretrial hearing.
Could you set it for sometime next week when you guys get the letter so you can understand everything I'm saying?
I believe we
Better.
will have to set it in due course in regards to the court's availability.
Yes, Your Honor.
May I inquire if a copy of that was sent to the city?
I mailed it off to the clerk's office, and also, Your Honor, could you please put on note that I requested that that letter get sealed due to the protection of innocent life, not only mine, but others that's at stake due to the information I revealed about me being a Native American Indian chief and the evidence that I've revealed in it. That, could you please put on note that I asked that it be sealed immediately?
And again, Mr. Evans, those sort of things need to be done in writing to the court. Mr.
I
Iona, do
did.
you have any concerns about competency?
I do, but I'm hoping that if the court sets a hearing next week, I think either on Tuesday or Wednesday, perhaps that letter will have come in and it might answer.
Okay, so for right now, I did sign the waiver of attorney, but I am going to allow counsel to remain on standby. Let me see when's the next time we can.
And Your Honor, would this be in custody or out?
This is in custody.
Thank you. So on the order, it's the top one and the very bottom one.
And also, Your Honor, I would like also to put on note that I mailed the letter off on a blank piece of paper and I numbered it. If it's kind of difficult to read, you might have to put something on each line because due to the circumstances, that's why I had to mail the letter off. I mailed the letter off. Because I was in a tank to where I didn't have access to anything. They had me in a restrictive tank while I'm on 23-hour lockdown. And I have no access to the law library or nothing.
All right, so we are setting these matters for May 29th at 11 a.m., all matters. If there's nothing else to address, this concludes this matter.
Just want to note for the record that the city is going to object to the motions being heard if we don't receive copies.
Did you hear that, Mr. Evans?
They're gonna, no, ma'am, could you repeat it, please?
The city has stated, since you are acting as your own attorney, that if they do not receive the information that you have provided to the court, that they will be objecting. It is a responsibility of you or your attorney to provide any information to the court and to the prosecutor.
All I can do is mail the letter off. I mailed it off. I don't know if the guards kept it or if it gets lost in the mail. I don't know. I can remail the letter or I can rewrite it and remail it off. But I mailed the letter off. I definitely sent it off, and I have the guard that picked it up. I have documented the guard that picked the letter up. So I definitely mailed it off, and it should be on camera that I handed the letter to the guard.
All
The
right, well,
city's entitled to an opportunity to respond. We would need it at the very latest by Monday. I mean,
I
if we're
mailed
setting
the-
it for Wednesday.
I mailed the letter off Tuesday. So it may get there today or tomorrow. Because it shouldn't take no more than 1 or 2 days for it to get right there to CTAC court. I mailed it and I put on there to the clerk. I attentioned it to the clerk. So that letter shouldn't take that long. If it doesn't come to you guys, that means it got lost in the mail or something like that, and I would have to rewrite it. I do have a rough draft of it. So I will be able to read it out to you verbatim Wednesday if you like, if you haven't received the letter by Wednesday. I did keep a rough draft of the letter, so I could read it out to you verbatim. Or if you don't mind, if you could give me a second, I can go and get the rough draft out of my cell right now and read it to you.
no, we are not ready to address that today. So we will
Okay.
address these matters again on Wednesday, May 29th. All right, so this concludes this matter. Bail, as I stated, will remain as previously set. as well as all previous conditions of release.
Thank you. Then we have to put the bail amounts in.
Yes, that's what I am
Thank you.
doing. And it's 500 each case, right, Ms. Chenmuller?
Yes.
Okay, thank you.
Could I get a copy of the paperwork, please?
You will receive a copy of the paperwork. All right, this concludes this matter.
This is Sylvester Evans, 3A0312319385492. Mr. Evans, I think this court heard him initially, but then there was time heard him, I think, last week. Mr. Evans has indicated that he'd like to represent himself on this matter and have our office as standby. I think the court granted that motion, but set this hearing to today because Mr. Evans indicated that he sent a letter to the court that had some requests in it. I don't know if the court received it and if a copy was provided to the city. I have not seen it.
I have not seen it. I looked in the court file earlier today and it was not there. Madam Clerk, do you know if we've received it?
I don't know why you guys haven't received it. Also, can I ask that this hearing is on record and that everything is being documented by a court reporter, please?
We do not have a court reporter. We're creating an oral recording though.
Okay, so will it be on record and will
Yes.
will it be able to be reviewed by federal judges if it gets to that or whatnot?
Yes.
Okay, I can read a copy of the letter. I mailed the letter out. There's no reason it shouldn't have reached you, but the letter had very personal and sensitive information regarding my sovereignty as a chief of a sovereign tribe that's federally and internationally recognized. I don't know why that letter didn't make it to you. I mailed it out last Tuesday, so it should have definitely gotten to you guys by now. I'm having issues with getting to the law library. I've been in the hole. It's like almost impossible for me to legally defend myself with the conditions within the jail. One thing I would like to ask, especially being that you didn't get that letter and I invoked my rights as a sovereign tribe, chief of a sovereign tribe, that if possible, you can give me a PR bond so I can properly get everything to you and make sure it's filed in the courts. I assure you, being that I invoke my rights as a sovereign tribal chief, that I will appear at court dates. I won't play with my rights like that. I have too much to lose. And I have a leg injury. But the main thing is my legal part and the getting the proper defense, and then the mail that I'm mailing out, it's not even getting to you. So I know I'm gonna have an issue defending myself from the inside of this jail. If you could do that for me, I humbly, respectfully ask that you give me a PR bond so I can at least properly defend myself, especially that I invoke my rights as a tribal chief.
I believe we've already had multiple bail hearings. I'm sorry, Madam Clerk, you were saying?
I was just going to say that there was a letter that was faxed in that we received yesterday, and I just forwarded it to all parties.
Okay, thank you. I'm going to take a moment to look at that then. I didn't see it in the file.
In addition to that, I introduced evidence that will exonerate me.
Mr. Evans, I can't read it and listen to you at the same time.
I'm sorry, Your Honor. Also,
Sir, I can't read and listen at the same time. I read slowly.
sorry.
Okay, I've read your letter. You've already had at least one bail hearing, because I remember it. I have not heard any change in circumstances such that you're not entitled to a second bail argument. Bail remains as previously set, $500 per charge. What tribe are you enrolled in?
All of that, I don't want to reveal that information because it's private. That's why I invoked also the Peace and Friendship Treaty between the United States and Morocco, in which I do qualify for that. And also you can contact the Embassy of Morocco.
No, so I'm familiar with that treaty, and it is a trade treaty. It has nothing to do with your right to commit crimes anywhere you feel like.
No, ma'am. It has nothing to do with me committing crimes, but they will vouch that I am royalty, and Morocco has granted me as part of their royalty, and they will vouch for me. I assure you.
You can't be a royalty in Morocco and a Native American. That's not possible.
I assure, if you look at the evidence that I submitted, I assure you I am.
I
Everything I'm
received
saying,
no evidence. I received just your letter. So
Right,
I'm not going
and
to,
and
I'm
the
not going to
letter,
grant, I'm not going to grant your motion to dismiss.
okay,
What are we doing?
okay. And I submitted evidence in the letter.
I'm not denying, I'm not granting a motion to dismiss.
I understand, but I submitted evidence in the letter as well.
I've considered your letter and I'm not granting your motion to dismiss.
I understand.
Okay, what are we doing?
What about the evidence?
What do you want me to do with the, I don't have any actual evidence. I have your statements.
Right, I submitted evidence in the letter. If you read it, you'll see that I submitted a civil case as evidence.
You submitted, you mentioned a civil case. I don't see the civil case. I have no access to this case.
I submitted civil case 24012 out of St. James Parish, Louisiana, as evidence that will exonerate me. And in addition to that, it will prove everything that I'm saying to be true.
I don't have that case, sir, is what I'm telling you. All I have is your letter.
Right. In the letter, I submitted civil case 24012 out of St.
Sir, I don't have that case in front of me. I don't know what's in it. I have no access to it. All I have
You have to
is,
retrieve it.
I have no way to do that.
You have
That's
to
not your
contact the
job.
courts.
Sir, that's your job. This is your case. You represent yourself. It's your job to put your case together. It is not the court's job. I ethically cannot do investigation on my own.
No, I'm not asking you to do an investigation.
You are. You're asking me to go retrieve something. That's an investigation.
I submitted civil case 24012 out of St. James Parish, Louisiana, as evidence that will exonerate me.
Then you have to actually get that case and put it before the court.
It's impossible for me to do that inside jail.
You have a standby counsel. Perhaps you can talk to him about it.
Are you going to be able to retrieve that case for me?
1 second.
Yeah, talk to your standby counsel. Maybe he can help you.
And Your Honor, I can make the records request. I don't know if it's going to have any luck receiving it. I mean, based on the information that I have.
The
Okay.
case has a seal on it, and you're going to have to get permission from the Chief Justice Roberts to get the seal broken.
I don't understand what the U.S. Supreme Court has to do with a Louisiana state case.
Because it holds my rights, as my constitutional rights and privileges as a chief of a federally and internationally recognized tribal chief, in which I represent a sovereign state.
Okay, so what are we doing today?
According to the letter, if you're not going to dismiss it, I asked that in the letter, I requested that you file a motion of discovery.
I can't file any motions. I'm not an attorney. I don't represent you. I don't represent the city. That is not my role.
Okay, and you said you're not dismissing due to lack of evidence.
Correct. I have read the police reports and did find probable cause to detain. And some of these cases are in review status. They've already been resolved and found guilty.
Okay, and also in those review cases, I said if the
Sir, I'd really like to focus on what we're doing today. I've denied your motion. We need to move on.
Yes, ma'am.
Okay, so what are we doing today? What's the plan going forward?
The plan going forward, I would like a fast and speedy trial by jury. I would like a motion for discovery to be filed. I would like a motion to suppress.
Sir, you represent yourself. You have to file those motions. Nobody, you asked to represent yourself. You got, Judge Rose-Akins granted that. So it's up to you to file those motions.
Okay, I just received the paperwork from Mr. Iannetti today on the format to file those motions. So I'll have those motions mailed out tonight.
Okay, perfect. All right, so we're setting this for trial, is what I'm hearing.
By jury.
Okay, so only the pretrial cases are going to be set for trial. I see the pretrial order has all the case numbers on it. Or does it have only the pretrial one?
Oh,
Okay.
I just clicked on it to give them an example of that order as well.
No, I think you've got all the right ones on here.
Okay.
1-5.
And I also asked that that letter be sealed due to the fact it has sensitive information on there regarding me and
You
my
have to file a motion to seal it, sir. I'm sorry, but this is why it's best not to represent yourself if you don't know criminal procedure. There's a whole process to having something sealed. I have to make certain findings. I don't have that motion in front of me.
Okay, I requested it in the letter, but I'll file a motion as well.
Okay. But I'd encourage you to read the Bone Club case so that you can understand what the guidelines are for sealing.
I haven't received any of that information, and also I need access to the law library, which is like I don't have any access to the law library.
That's something you'll have to talk to SCORE about. So has any discovery been provided?
I gave them the narratives.
Police reports, that's it.
Ms. Chenweller, is there additional discovery?
Can certainly check.
Yeah, is 14 days sufficient?
Yes.
Will the city, first of all, is there a motion to join and consolidate these cases for trial?
Yes.
Any objection, Mr. Evans?
Yes, I do have an objection.
So then you realize it'll take roughly 4 months to try these cases.
Will I be sitting in jail the entire 4 months, or is it 60 days still?
The problem is we can't try, if you're not going to agree to try them simultaneously, I can't guarantee you they'll all be tried we only do jury trials 1 week out of the month.
But my question is, will I have to sit in jail 4 months or 60 days?
Potentially 4 months. I can't rule that out. And I'm not trying to pressure you into agreeing. I'm just setting out the facts. You do what you want to do.
I just explained what joinder means and the benefits and disadvantages of joinders.
So Mr. Evans, what do you want to do?
I want to do them all separately.
Okay, caution. Will you be filing any motions to suppress under Rule 3.6?
I'll be filing motions to suppress and subpoena.
Are there additional witnesses you'll be calling?
Yes, ma'am. I would like to subpoena the airport director or the operations airport so I can have those guys verify that I was there. The reason I was there is legal airport business.
Ms. Chenweller, is including SeaTac airport operations sufficient to put the city on notice of who the defendant will be calling?
No.
Okay. What would you accept? I don't know how to put this because I don't think Mr. Evans knows who this is right now.
I believe the onus is on
director
the
of the
defendant
airport.
if he wishes to identify and subpoena that individual or individuals.
Okay, so as soon as you figure out who it is, you have to put the city on notice.
Lance Little, the managing director of the airport.
Okay. SeaTac Airport Managing Director Lance Little. I've included that.
Got it.
Will you be offering any affirmative defenses?
Is that a question to me or the?
Yes, it is. It is.
What's your question again? I'm sorry.
Are there any affirmative defenses?
Could you reword that, please?
Perhaps Mr. Ainati can help.
Yes, 1 second.
A few moments later.
Yes, ma'am, I do. I will be providing an affirmative defense and the right that I was a law-abiding citizen at the airport.
So I think that's general denial. That's not an affirmative defense.
Well, also that I was a passenger of a business that operates legally in the airport, of a charter bus company that legally operate. I was a customer of a charter bus company that legally operates in the airport.
So still, that's just general denial. That's saying I didn't do it, not an affirmative defense is saying you did it, but there was that you were allowed to do it.
Right. I was at the airport, and the reason why.
So that is general denial. That is saying there was no crime that was committed. That's what you're saying, right? That you did not commit any crime.
No, I'm saying that I was a customer of the airport.
Right, which would not be a crime. It's
Correct.
not an affirmative defense. An affirmative defense would be saying I trespassed, but I had to because I was being chased by someone and I ran into the airport for safety. It was necessity is an affirmative defense.
Okay.
Lawful use of force is a defense.
In that
Just
case,
saying I didn't do it, I was allowed to be there is not an affirmative defense. It's a defense. I'm not saying that it's not a defense. I'm just saying it's not technically an affirmative defense such that you have to put the city on notice.
okay, according to your definition, I guess it's not an affirmative defense. But once again, could they close the door so I can make sure I'm hearing? Can I re-verify that everything is being recorded and that everything's on file? And I would also like that a court reporter be present for all future hearings and possibly for this one as well, if possible.
We will not have a court reporter. We are not required to. We are not a superior court. We don't have a budget for that. We record everything. Everything is recorded. But we do not have a court reporter. We do not have access to a court reporter, and I'm denying that request.
Yes, ma'am. And also, could I file a motion to appeal that?
You have to actually file it. You can't, you don't need my permission to file a motion. You can just file it.
I mean, a notice to appeal, I'm sorry. So I would get that information from Mr. Ionetti because I don't have any access to the law library to get these motions or notice of.
Sir, you have to have a basis in law to request that. I can't imagine. We are not courts of record in that sense, like a superior court. We do not have court reporters.
I understand, but I feel my constitutional rights are being violated.
So we have there isn't a recording of everything. Everything can be recorded and transcribed, but we don't have a real-time court reporter.
Okay, what's the difference?
I can explain.
I'm ready, Your Honor.
Okay. And it looked to me like what is current speedy in custody, Ms. Chenweller, do you know?
719.
Thank you. All right, Mr. Evans, bail remains $500 each case. We'll see you back here, each count rather. We'll see you back here on June 12th at 11 o'clock in the morning. Stay in touch with Mr. Ionetti. He can help you.
Ms. Judge, Your Honor, my bail was raised. Is there any explanation for my bail being raised? Some of my cases was $250. It went from $250. Yes, ma'am.
Oh, I'm sorry. Did I mean I just said that I changed it right now? I see that.
It was changed by the previous judge. It was raised to $500. She went just off the notion of what the lawyer said, which was inaccurate. And then the inaccuracy was passed on to you as well. And then you were about to redouble down on it.
All right. Thank you for pointing that out, sir. I'm restoring bail to $500 per case.
You mean $250 for some of the cases? And
well, it's $250 per count on cases that have 2 charges.
All right. Let me take a look at the paperwork I got, and I'll let you know which one said $250 bail.
Yes, Your Honor, I believe that the last hearing that it was pro tem judge and she said it at 500 per charge. And I think she misunderstood that when Ms. Chenweller advised her, it was supposed to be 500 per case.
Correct.
Okay, for a case ending in 2319, that was $250 bail.
No, see, there are 2 counts. Look down below it. There are 2 counts. There's 1 count of criminal trespass in the 1st degree and one count of making a false statement. Both of them are 250. It's one case.
Okay, so you combine the two charges and it comes up to 500. I got you.
Correct, correct. So it's 500 per case, but I'm restoring it to that. I believe there was a Scribner's error in the last order. And I thank you for correcting me, Mr. Evans, or pointing that out. So it is now, so on the case, and similarly, the case ending in 525, that's the last case. There are two charges on that case as well, and it's 250 each charge. Okay, so then
So was I right or wrong?
you were right. I mean, I put it back the way it was, 500 per case.
And you say you set a trial date too as well?
Correct. Readiness is on June 12th, and then the trial will begin on June 24th.
Okay, and I'll have trial for all 4 cases on the same day, or?
We can't possibly do all 4 in one day. We're good, but we're not that good.
Gotcha. So,
One second.
Oh, they're very close, aren't they? Okay. I see.
And yeah, but the pretrial won't be 4A. The review would be 3A, and then it ends in 525.
That's review. 898 is a pretrial, right?
It should be. I believe it was listed as arraignment, but
I think
believe
it's
the defendant was arraigned.
right. I agree. That's what my review of the docket. And 191 is a pretrial. And 552, that's what's was getting me so confused. There's 525 and 552.
Mhm.
And 552 is readiness. So
and also the letter that I sent you, it's gonna be on file for the public to see all the information I have in there?
until I receive a motion to seal and we have a hearing on it, yes.
Did you read the backside of it as well, what I
Yes.
said? Okay,
But sir, so this is why I'm encouraging you to look at the Bone Club case, because that sets out the criteria by which a court can seal a document. It's not, I can't just seal it because I feel like it or because you want it sealed. There has to be a
it's
justification.
a matter of national and homeland security.
You can't just say that. You have to show me why it is.
Because it's an investigation.
So again, you can't just say things. You have to, I need the whole story, not just little bits.
You
And
would
just so
have,
you're aware, we are streaming this hearing live on YouTube before you go any further than you want to.
right, so my whole life is in danger at this moment because of this. I clearly wrote in a letter that I'm connected to an investigation that is a matter of national and homeland security.
But you can't just say that. You have to show me the whole thing. I can't just take your word for it that that's an issue. You're muted. You're muted.
I gave you the evidence to prove what I was saying as well.
But you didn't. You just said, I have this thing. You didn't, I don't have the thing. I need the thing.
I gave you the evidence in civil case 24012 out of St. James.
Okay,
Parish,
we're
Louisiana.
circling, sir, we're just circling back to things. I do not have that case in front of me. You have to present that case to the court. You can't just say there is a case.
So I have to do it in a motion form, or do I have to, for me to physically get a copy of that, it's impossible for me to do it. My lawyer probably can do it, but it's impossible for me to do it from within inside.
I understand, and we had this discussion at the beginning of the hearing, and you've talked to Mr. Iannotti about that. I can't do any investigation. I am not your attorney. I'm the neutral party. I'm not the city. I'm not you. I will do no investigation. That would be, frankly, I could be sanctioned for doing that. It's up to you to present evidence to the court. It is not the court's job to find evidence.
Okay, in the letter I did present it as evidence.
It's not evidence. It is just claims.
All right, so I actually have to file an actual motion as evidence, and
It's not the motion. You have to file the evidence, the thing itself.
you mean the actual physical copy of the civil case?
Yes, that is exactly what I mean.
I don't have the actual copies of the civil case in front of me due to the fact that I would have to call the courts to get it. And I cannot do that from inside of this jail, and they will not fax that to me from the inside of this jail.
Okay, so we're having the same conversation over again. You can talk to Mr. Iannotti about this. But I can't, there's just a limit to what the court can do. All right, thank you, sir. We'll see you back here on June 12th. Have the parties had an opportunity to review the evaluation?
Yes.
Yes, Your Honor.
Did either party take exception to the court adopting?
I have an objection.
Object to the court adopting the evaluation?
What's the status of the evaluation? Was it competent or incompetent?
I'm not able to proceed.
So I mean they found me incompetent?
Yes.
Okay, could I see the paperwork on that so I can review it and have that challenged?
So just to be clear, if you're incompetent, everything gets dismissed. If you're competent, then everything proceeds.
So that's what I'm asking. Did the doctor find me competent or incompetent?
Incompetent.
Okay, under what circumstances? What was his reasoning?
Delusional thinking.
And what proof did he have on that?
I mean, the interview that he did with you.
Okay, and being that you said everything is dismissed due to delusional thinking by law, from what I read at the law library, it said being delusional in itself is not reason in itself to be declared incompetent.
That you are unable to assist in your own defense because of it. So there are two prongs, there are two ways that you can find someone unable to proceed, that they don't understand the nature of the proceedings, which you clearly do, and the evaluator said that. But that you were unable to assist in your own defense due to the delusional thinking.
Well, that's being with the letter that I sent to you, that would directly refute that, correct?
No, that supports that.
What the letter I sent to you, it had motions that I wanted filed and whatnot that would prove that I'm able to assist in my defense, correct?
No, it was, you wouldn't give me any information. You gave me half information about things, refused to give the further information when I asked in court.
I did declare that the information regarding the evidence, that was a matter of secret state privilege. And then I also declared that the motions that I want to file, I didn't have access to the law library to get the proper documentations.
I am adopting the evaluation over your objection and finding that you are unable to proceed in these matters. So the pretrial cases are dismissed. All of the reviews are closed pending a further finding of able to proceed. The evaluator did not opine that you should be evaluated by DCR prior to release, so you're just released today. You can appeal this. You're welcome to appeal this finding, this ruling, and you could come to the court and the clerks can tell you how to do that, what paperwork to file.
All right, so I'll be released from jail today.
Correct.
And also, can I get the paperwork of the evaluation from the doctor?
You represent yourself, so I think you kind of have a right to it.
Yeah, how do I get that paperwork?
Mr. Iannotti, are we able to print that out for him?
You can print it off and give it to the officers to give to them.
Okay, we'll get that to you today.
Okay.
All right, thank you, Mr. Evans.
And also, I want to put on record that I want to file a notice to appeal to the Supreme Court of the state of Washington.
That's appeals from courts of limited jurisdiction go to King County Superior Court.
I understand that, but I want to bypass the Superior Courts and go directly to the Supreme Court due to the circumstances and the nature of the judgment.
Okay, you can try to do that.
I want it on record noted. If you
you
have
to actually file it. That means nothing. You have to actually file the documentation. You have to file notice.
That's impossible to do from in here. You're saying when I get out, I have to file it?
Yes, correct. You'll have 30 days to file it.
Okay.
Okay. You should know, though, that you are still trespassed from the airport. Nothing in what I've done today affects that. That is the airport's trespass notice. It is still fully valid. You will be rearrested. Okay?
So even if I'm there on personal travel, I'll be rearrested.
You have to comply with their rules and restrictions. I'm not going to give you legal advice as to what that constitutes, because you need to look at your trespass notice. But
yeah, I was there this time on legal business.
We're done. We're done with this case. This case is dismissed. So we don't owe me any explanations. I'm just telling you that the trespass order from the airport is still out there. Okay? I'm just letting you know.
Okay, so I can still be arrested under false premises, because they also said I confessed in this case, which was not true.
I'm just telling you that the trespass order is still there. That's
Okay.
all I'm telling you. Okay. Thank you, sir.
Okay. Also, what I want to fire Mr. Iannetti as
He
well.
doesn't represent you. We've already gone through that. He doesn't represent you. You can't.
Okay, well, is he going to give me the paperwork that I need for these proceedings?
Score will.
Okay, and the evaluation as well from the doctor?
Yes, I believe we'll be printing that out. Mr. Inati said he would print that out for you.
Okay.
All right. Thank you, sir.
Well, what is going on with the review cases? I guess I haven't
They're
heard
all
that part.
closed. They're all closed, pending a further finding of able to proceed. If maybe
Closed. What does that mean?
it means there are no affirmative conditions no conditions can be imposed because there's a finding of unable to proceed.
So they can be reopened later.
They can.
So I can have a warrant placed and I don't even know it once again.
Well, no, you would have to get notice of a hearing.
Like this time, I didn't get notice of the review hearing and they placed the warrant out for failure to appear. I didn't even know I had a hearing on the review charges.
Okay. This is why it's very important to keep your address updated.
My address is very, I don't know, for lack of a better word, I do a lot of moving around, so I don't have a steady address that I can always get mail at the moment. So that's how we got in this position the first time.
Well, that sounds like, I mean, if you're not going to let us know how to get in touch with you, then you can't complain when you don't get notice.
I can give you an email. Would you be able to contact me by email?
And I think we have that listed.
But they never gave me a notice of any hearing via email.
Okay. We will make a note, email only.
And I'm still confused as well. The case is open or closed?
Closed. He's unable to proceed.
And I'm confused by that. So the conditions were, there's an allegation that he violated him. He's not found competent. We can't move forward in those violations, but it doesn't invalidate the conditions that were set because those were done at a time that he was competent. Like, is the court still taking jurisdiction? Like, I'm still struggling with that.
I can't impose conditions.
The conditions were already imposed, though.
I know, and they're stayed. Everything is stayed.
Sure.
Like,
But so the case is open but stayed, or is it
I guess
closed?
that's maybe a better way to characterize it, but it's for all intents and purposes closed, effectively, pending a further finding of able to proceed.
And also, would I be able to subpoena any grand jury proceedings that may have taken place as well?
There are no grand juries in courts of limited jurisdiction, and I don't believe there are in Washington at all, other than federal.
Okay. And so you said, yeah, I'll get a copy of the evaluation, and you say I got 30 days to start filing motions to try to get everything reversed, right?
At this point, your only avenue is appeal.
Correct.
Okay. All right. Thank you, sir.
So I think the city is objecting to them being closed in any way.
So they're not closed. They're just, I mean, I thought we talked about this.
I know, but when we're using words like closed, is there going to be a CL for closed disposition?
No.
Because that's what's going to be in the docket is they're closed. And so in a year or two, if this comes up again, it's going to be very difficult to figure out what exactly happened today.
Well, in 2 years, it's too late. Jurisdictions run.
Sure, there's some situations where that wouldn't be the case, but so the cases are open is all I'm trying to understand.
Yes, they are not closed, they're just,
Okay.
Okay, so would you be able to clarify that for me, Miss, Your Honor, in layman terms, so I can get an understanding, because you said it's not closed, but it's open closed, which is kind of difficult for me to
and
understand.
you guys are right, I should use more careful language. The cases are open, they are stayed, which means frozen, essentially. Unless there's a further finding by a doctor that you are able to proceed.
Would that be able to be done in the appellate courts or the state Supreme Court, or overturning his findings, or what? How do you get the proceedings to be found? How do you get that overwritten, basically, what the doctor prescribed or diagnosed?
So, and this is interesting. It's a situation I haven't come across where there's an individual wanting to contest the finding.
Yeah, based on, I don't have the law library's information in front of me, but based on the information I got from the law library, a defendant cannot be declared incompetent by being delusional in itself.
And
That's
I
law.
explained to you what the evaluator opined, that your delusion is impeding your ability to assist in your own defense. That's what the evaluator, am I characterizing that correctly, Mr. Mercer, Mr. Ainati? That's what it sounded like to me.
In what way though? How is it impeding?
You're asserting defenses that don't exist.
Such as?
The stuff about the case in Louisiana.
I asserted evidence that has a seal on it. So the only way he can find out that it doesn't, what I'm saying is not true, is to get the seal broken on the evidence, which is under state secret privilege. And the only way you can get that broken is by orders of the president or Chief Justice Roberts of the United States Supreme Court.
So when you get all your ducks in a row to get that happening so that the court can see it, it sounds very far-fetched. I've never heard of anything similar happening on a state case that the U.S. Supreme Court would involve themselves, much less that any one justice would have authority to unseal something. I'm adopting this finding. You can appeal.
Is everything that we spoke about today on the record? Would I be able to get recordings of all the subpoena recordings of all the hearings, including what we're talking about today?
They are all online, available for you to listen to anytime you want.
Okay, and they all can be subpoenaed by the state Supreme Court and whatnot to be overturned or sealed. Also,
they are not going to do any investigation on your behalf. If you're appealing, you have to do all the investigation.
Right. No, I don't need them to do the investigation. Everything's pretty much said and done. The only thing is the assumption that you guys don't believe the evidence is under state secret privilege, and I am who I'm telling you I am. So you're believing I'm delusional. Am I correct?
That's correct.
Right. So y'all making assumptions that's not true, that I have to go through the process and get everything removed to the federal courts to prove that it's true, which is going to be under seal at that moment. But I give the state Supreme Court a chance to make the adjustments and override.
Okay. Thank you, Mr. Evans. You'll be released today and you can get working on that.
All comments, viewpoints, interpretations, and insights expressed in this video are for education and entertainment purposes. All individuals featured in the video are to be presumed innocent until proven guilty in a court of law. Please do not attempt to contact, locate, or engage with any individuals featured in the video.